Hi everyone, it's Kerry Griffiths, the Divorce Financial Planner, Willow Brook Lifestyle Financial Planning. Thank you for joining us today. I'm joined by a guest and we're going to talk you through the divorce process. Well, my guest is going to talk you through the divorce process. So if you are at the very beginning and you're not sure exactly what's going to happen, then this is a video for you. So my guest is Chrissie Cuming Walters. She's a specialist family law solicitor and a US attorney. She's a partner at Keystone Law and she's currently shortlisted for the Women in Law Awards 2020. Well done, Chrissie. I know Chrissie really well. We actually met earlier this year and we shared a stand at the divorce fair and we had a whale of a time. She is a maverick. She's a fierce New York litigator and she is becoming something of a disruptor in family law with absolutely brilliant client testimonials. So she's the perfect person today to kind of give us an insight into what that divorce journey looks like from a legal perspective. Hi, Chrissie.
Hi, Kerry. Thanks for having me.
No worries. So we're going to kick straight off, Chrissie, and I want you to help us understand what's going to happen right from the very start. So let's imagine I'm a client and I give you a call. I've literally not spoken to anybody, but I'm thinking divorce is the right way forward. What would happen?
Right. So at the moment, what would happen is we would do some information gathering, twofold really. And the first would be, I would need to have some understanding as to why you've reached the decision to pick up the phone and call me. Not necessarily me in particular, but what's happened within the marriage, what's happened in your recent history that's led you to take this really difficult decision or to even consider taking this really difficult decision. Because that will inform a lot of strategy and that will also inform a lot of thinking about best outcomes for you going forward. So that's number one. That's still relevant because even though no fault divorce got royal assent last week, the Law Society Gazette has said that it's probably not actually coming into effect until autumn of next year. So the unreasonable behavior or blame petitions, as they're being called, is still probably going to be the most common way, at least for about another year.
That makes sense.
So that's number one. And then number two would be information gathering in respect to finances. We're not going to talk about children in this little chat here because we're very focused at the moment on the divorce process itself. That would be maybe a recording for another time. So talking about the finances, that is definitely information gathering sort of at the higher level. So you need to know things like, what do you have? And I say that sort of tongue in cheek, but you'd be surprised about the number of women in particular who, when they first pick up the phone to me, they really don't know what the marital assets are. So you do need to start asking those questions, either of yourself or of your spouse. If you have an accountant, if you have a financial advisor, we need to start building this image of what actually is in the marital pot for distribution so you can start planning for your future. Right. So that's really important. We're talking bank accounts, anything valued over £500, not when you purchased it, the value of it now. So there's a bit of a difference there. Your mortgage, do you have one? How much is it? Your home, which is usually going to be the largest asset, what is it worth? If you've got no idea, go on to Zoopla. It's a brilliant tool for starting out. So, check all of those sorts of things. Maybe, talk to a friend who's been through a divorce, but remember that every divorce is different. So what happened for A may not happen for B. If you were in court C, it's different than court D. Everything can be very, very different based on circumstances. So that's just to get you started. Now, I can do that with you, or any other solicitor can do that with you, or you can come to me sort of with that information already at hand. If you want that initial chat to be information gathering to the point of, well, this is what I think we've got, what would the court do? Give me a range, then have those documents, that information available. If you want more information as to, how do we get through this? What should I be expecting? My husband perhaps is narcissistic, or, he's been really financially in control and I'm not really sure, then that's fine too, because we'll get to that point. So don't think that if you don't know what the financial situation is that you're actually at a loss, because we will get there for you. So once you've sort of got that rough bit of information going on, and I know more about you and your needs and how you've come to me, or again to any other solicitor, then we need to start talking about getting the actual divorce rolling. Right? So again, going on to the blame petition, as it's been called in the media, the unreasonable behavior. Now, what is that, right? What is that? Well, in this jurisdiction, even when no fault divorce comes in, the only basis for marriage breakdown is the irretrievable breakdown of the marriage. So there's no chance you're going to get back together, right? And there's a couple of different ways that you prove that it has irretrievably broken down. The most common of those is unreasonable behavior. And then you've got 2 years separation with consent of your spouse, 5-year separation where you don't need consent. And then there's other things like adultery, which I never recommend going down that route for various reasons. There's also abandonment and the avoidable marriages and those sorts of things. But the most common remains unreasonable behavior. Now, the blame game. You don't have to be nasty. You don't have to. You just have to prove to a third party, the judge, that you're not going to be together anymore.
Yeah.
So, do you still share the same bed? Do you, behave as a married couple, or do you behave more like two tenants who are living in the same house, sort of ships passing in the night? That sort of thing, which is very common, actually. People just kind of stick in because, well, that's what they're used to. And that's fine. That's a reasonable ground. You might need to, bump it up a little bit, like, it makes me feel sad, it makes me feel lonely, it makes me feel depressed. But, that can be sufficient grounds.
Okay, yeah.
So, it is something to bear in mind. It's always been something that can be anodyne, and it's always been something that can be actually agreed between the parties as well. So that is your little blurb about what goes in the document called the petition, right? And the petition is what kicks everything off. The petition is what starts the divorce process. Okay. So that goes to court, and you're telling the court why the marriage is broken down.
Okay. And it goes to your spouse as well?
It does, yeah. So if you have a solicitor, the solicitor can ask for what's called solicitor service, which means that the solicitor will serve it, or have a process server serve it, which is recommended if they're a bit slippery. Or if you don't mark it like that, then the court will automatically send it out to the other person. So you'll get a copy, and the other person will get a copy pretty much on the same day. Okay. So that starts the whole process, right? From there, it is something of a conveyor belt in most cases. We don't have time at the moment to be talking about things like defended divorces and putting in answers and all of that sort of stuff. It does usually go quite smoothly from that point, where the other party will get served. They'll get a document that's called an acknowledgement of service that they have to fill in and send back to the court that says, yes, I've gotten the petition. Yes, I agree with what's said. No, I don't agree with what's said. Yes, I agree to pay the costs of the divorce. No, I don't agree to pay the costs of the divorce, or what have you. And it goes back to the court. The court seals it, sends it to you, person who started it all, sends it to you or your solicitor. And then that allows you to make the application for the interim decree of divorce, which is the decree nisi.
Ah, I see. Okay. Yeah.
Now, a lot of people will get themselves very worked up about the acknowledgement of service, right? 9.9 times out of 10, whatever nonsense they scribble on that acknowledgement of service doesn't really make much difference and realistically in practice. If they say they don't agree and they're going to defend, then they actually have to do it. That in and of itself isn't enough. If they say that they're going to answer, they've got to do it. It does start different clocks ticking, but they do actually have to take that proactive step, and they do actually have to incur those costs, and they do have to incur that risk as well, that the court will still find that the marriage is irretrievably broken down, because at the end of the day, that's really what the court is looking at, is has the marriage irretrievably broken down.
Okay.
So, and also, if they say, well, I don't agree to pay the costs, if you've ticked the box on the petition, the court will make the order anyway. So that, there's a lot of sort of emotion that goes into these steps, and there's a lot of almost sort of fighting it out to try and gain some sort of position or to regain some control when all of a sudden so much control has been taken away, particularly if you were sort of a dominant spouse and, you know, you kind of ran the household and those sorts of things. And all of a sudden, you know, you've got a petition that maybe you weren't expecting. So it can be really important, particularly during this time, if you're more vulnerable for whatever reason, either financially or because you've just been put through an emotional ringer, or you're coming to this decision, that you do have some support in place. Ideally, you can work with a team, a tribe behind you of a solicitor, a financial advisor, maybe a divorce coach or a counselor of some sort to get you through these sort of stumbling block moments that you will have, because there will be stumbling block moments where you think, you know, I'm just not sure that I can keep doing this. But you have to remember that there is a reason why you're doing it.
Yeah.
And there's a light at the end of the tunnel. You will get through it, and you can recreate a new future for yourself and your children. So that's the one sort of thing to bear in mind, is that you can make a better life for yourself. You've just got to see the process through. So that's the main sort of first bit in the divorce process. And the reason that I said that first is because it's really important that you get through those initial steps before you start getting down to the nitty-gritty of negotiating the finances.
Okay.
If you're minded to negotiate, if you want to go to mediation, if you want to use, perhaps you're religious or you're of a community where you look to elders and those sorts of things to help with these situations, that's fine. But you need to be getting through that bit of the civil process, because if you agree, let's say you go to your spouse and you say, you know what, I can't do this anymore. I know that really I should probably have more than 50%, but I don't want to fight. I really just, I'm over it. Let's just say 50% and be done. And they go, yeah, okay. All right. Now what? If you don't have a divorce underway, if you're not at your interim decree or decree nisi stage, the court can't endorse what you've agreed. You're sort of in this odd limbo where things can go wrong, and particularly if you've negotiated it between yourselves without solicitor involvement, can they be held to that agreement? And sometimes there's questions around that, particularly where there's not been financial advice, particularly where there's not been financial disclosure, where there's not been legal advice. Is that binding? Is it actually more of a post-nuptial agreement, which can be given weight, but is not actually binding? So, better to not get yourself in an even more costly pickle by trying to do it the wrong way around.
Yeah, that makes perfect sense.
Which is very common, actually, because people want, it is that feeling of needing to be in control of this process, that you sort of hit the ground at a run, as it were, and you sometimes get ahead of yourself and realize that actually you might have gone a bit off track.
I see it a lot, Chrissie. I see it a lot with clients who come to me and say, oh, we know what we want to happen. We just need to go and put the divorce in. And I'm like, okay, so what do you want to happen? And then we actually unpick yours. Like, okay, we're quite a long way from where you should be now.
Yeah. And a lot of times they've not thought about things either. Yeah, because you are in this sort of strange bubble. And I've been through it myself, so I know that you get these sort of blinders on, and it's a lot of coping mechanisms and processes that are at play as well. So you might not be thinking 5 years from now. It goes back to that question: are you mortgageable? Well, even if you are, what happens in 5 years' time? What happens if you've lost that job and you said, you know what, I don't want a pension. I don't want your pension. It's fine. Oh no, that's your savings. I don't mind. You keep that. And now you've got no liquidity. You've got no net. You've lost your job, and now you're not able to pay your mortgage on a property that you thought was going to basically be your safety and security, sort of into your old age, and now it's not. And you've got to think.
It's a complex picture, isn't it? It's a really complex picture.
Very complex picture, and it's absolutely not just about now. It's about 5 years from now, 10 years from now. It kind of depends on what age you are when you take these decisions. Most of my clients tend to be sort of between 40 and 50 for the most part. So they do need to be looking at pensions. They do need to be looking at retirement plans. They do need to be looking at the sorts of protections that you can provide for them. So that sort of gets us to that point where I go, okay, well, we've negotiated. Are we agreeing? We're at interim decree. We're negotiating. Are we agreeing? If we're not agreeing, say we're not agreeing and move forward. There's so many clients, again, women in particular, who are so desperate to remain amicable for whatever reason, usually because of the children, or because they've been told that if they get a solicitor, they're going to spend $100,000 plus, which just isn't true. I mean, I'm a London lawyer, and I am a partner, and on very few occasions do I have any cases that go $100,000 plus. So there are those that do, but you have to remember that even if you have a solicitor, you do retain control, and you should choose your solicitor as being somebody who you can work with, and somebody who you can trust, and somebody that has your best interests at heart when they're advising you and taking decisions with your instructions. So if it is about costs, does the lawyer need to go to the FDA? Probably not. Do 3 lawyers need to go to the FDA? Absolutely not. Those sorts of things. So there are ways to control costs. And you need to take the decision as to whether or not the negotiation process is going to work. And if it's broken down, it's broken down. And then you issue, as we say, financial remedy proceedings. What does that mean? That is a Form A, is the document that you send to the court that says, sorry, court, we couldn't work it out. Yeah, we've tried, really sorry.
And you're better off doing that sooner rather than later if you know you're absolutely never going to agree. Why waste all that time back and forth,
and money and emotion and energy, and things change. And that's one of the difficulties with the financial proceedings, is that it is a snapshot in time. You've been negotiating for 2 years. The pot that's available when you finally go, you know what, I've had enough and we're going to court, the pot that's available has significantly changed from the pot that was available when the process started.
So if you can see quite early on that you're not going to get to a common ground, then you're better to move things on. And then that's when, then you do the Form A.
Absolutely. And that's not the end of the world either. People need to understand that most cases don't go to a final hearing. And there's lots of mechanisms available now in particular, but others that have been available for donkeys, to help people reach a settlement, reach an agreement during the actual court process. So it's not, sort of like, there's a lot of pressure. I think I said this at the divorce fair, that there's a lot of pressure on women, again, in particular, to divorce the right way. You don't have to agree. If it's not the right deal, it's not the right deal. If it's not going to get you what you need, it's not the right deal. And it's okay. And you can get into the actual process. You can get the court behind you. You can get that timetable. You can get that structure, especially when they're not giving you full disclosure. Absolutely necessary. And then you can say, look, okay, well, now the judge has said, at the second hearing, the judge will give an indication as to what they would order if it was a final hearing.
Perfect.
So knock their heads together. And you go, look, well, the judge has said that I get X. Why aren't you giving me X?
Why waste any more money on this? Let's just move forward.
And most cases will settle at or around that second hearing, because then there's cost consequences. So if the judge says you should get X and your spouse is going, nope, I'm only offering Y, that's it. And you go to a final hearing, you incur those costs and you get that X. Well, now they're not paying for all of that in between, but they're going to pay for some of it. And so there are cost consequences that do attach at that point. But at the end of the day, it's about getting that final order. It's about getting that finality, whether it's by consent, you've agreed it, or whether it's the court has said this is what it is. And that is basically not your golden ticket, but let's say a silver ticket, shall we? So that is going to be the document that's going to help you rebuild your life. That's going to say, this is your distribution from the matrimonial home, or you get to keep it, or you bought your spouse out, or whatever it may be. This is your distribution from the pensions. All of that work that you've put into the marriage, even if you've not actually left the home to work outside and you've worked in the home, that counts.
It does.
Because you've supported that household, you've supported your husband in making that money that built the actual assets. That is still considered a bona fide contribution, as well it should be. And so, this is the culmination of that work that you've put in. And, and this is going to get you that future that you've envisaged. And, one of my favorite things to do is, particularly where it's a woman who put her career on hold for the family, and really just can't imagine what on earth it is she's going to do after all of this. And to see her built back up through this process, and to start to dream again and say, you know what, I can go and I can train to do this, and I've always wanted to do this, and now this is my chance to try. And you can build that sort of stuff into what you're asking the court to award, or what you're seeking from your former spouse. And there's so much opportunity there that it doesn't have to be a negative.
Absolutely, and there's so much value given to the contribution that you've made, isn't there, in terms of kind of that being at home side of things and putting your career on hold. I just wanted to say here, I have actually got a video with Laura Dougal, who is a careers coach, talking about exactly this, Chrissie. So do look out for that on the playlist here, because she's talking about that opportunity and how you grasp it, and how you kind of redirect, restart, or reimagine a career that maybe has been put on hold or was stopped in its early days.
Yeah, I mean, it can be just a tremendous growth opportunity. So, and you get that final order, and that's where the divorce process itself comes back in, because you need your final decree, your decree absolute. And if you're the financially weaker party, you should be advised not to apply for that until the finances are sorted out, because it leaves you exposed. So you get your decree absolute, you get your final decree, you've got your final order, they sort of come together, and the one affects the other. So the decree absolute sets the time that this comes into effect, right? So most of the orders will come into effect on decree absolute, and some will come in within 28 days of decree absolute. And so then when that lump sum is being paid, or that first lump sum is being paid, and those sorts of things, and the timetable that you need to start getting stuff moving, as it were.
Perfect. That has been super, super useful, Chrissie. I think a lot of people won't know right at the start what they're doing is all the considerations that you've given there, specifically around, I think, that part where you have to go into it with the picture that actually you might need to stop negotiating, and not actually see it as where you're fighting solicitor as actually being the divorce, because I think that's what people think divorce is. So the two solicitors negotiating and fighting and kind of years of this, whereas actually you've got the control to say, no, let's put a stop to this and let's move it forward, let's put the Form A in and actually move things forward. So that's been super useful. I'm definitely going to have you back, Chrissie. There's so much more to talk to you about, but thank you very much for your time today. And your links and your website, so if people want to know a little bit more. Chrissie does actually have this most amazing flowchart that talks through what she's just outlined there as well. So I'll hopefully get a link to that. If not, it is on her website, isn't it, Chrissie? Is that on your website, that wonderful flowchart?
It should be.
We'll make sure we can get a copy of it for you.
I haven't looked at my website in months. It was one of my sort of, during lockdown, I'm really going to be working on the website, and it was just one of those, it was that one step too many.
I agree. Yeah, I know that feeling. We'll make sure that you can see it though, guys. So I will put a link to it, or we'll get it on her website. And thank you very much, Chrissie, and I'll speak to you again soon.
Thank you, Sarah.